Hello, and welcome to another edition of Positive Parenting. I'm your host, Luke Spiegelhoff, therapist and parent educator. Today's topic is one we often don't talk about with parents, and that is choosing a guardian for our children. Now, part of the difficulty with this issue is that it often comes up around issues where we might be incapacitated or not able to make those decisions. So we brought in an expert to help us understand guardianship a little more and what is involved in that process. And with us today we have Andrew Lehner, who is with the Lehner Law Office. Welcome, Andy.
Thank you.
Andy, talk to us a little bit about this whole idea of guardianship. What exactly is it and how is it involved legally?
Sure. Well, obviously, parents who have children are their children's guardian. That's how we operate day to day. But like you pointed out, when there's an instance when a parent can no longer provide care, the question's raised, who should be providing that care? And that's where we get to today's topic. A parent has the ability to name a person of their choosing, or a couple, or a group of people is appropriate sometimes. But a parent has the ability to name whomever they'd like to serve in their capacity as parent or guardian if they're unable to provide care. So from a legal standpoint, this needs to be done because somebody's going to have to provide care, and the court's going to be the decision maker unless a parent makes that designation in advance.
Okay. So what should parents be looking for when they're looking at choosing a guardian for their child? What are some of the qualities, some of the things they should be thinking about when considering that?
Sure. Well, many of them would be, I guess, similar to what you would envision a good parent, of course. But some maybe less common considerations would be that of geography. And what I mean is, if we live here in St. Paul and our favorite sister, who's going to be an excellent parent to our child if something were to happen, if she lives in Texas or something, do we really want to send the child to Texas after they've perhaps lost a parent? They're already dealing with an immensely traumatic situation. So geography is a consideration. Also, just stability of the home, and that's a little bit obvious to a certain extent, but financial stability, emotional stability, all of these things should be considered when choosing a guardian. Also, just familiarity with the child. And an important thing that sometimes parents overlook is that the chosen guardian would actually know the parents well. You'd want to choose somebody who understands your style, understands your values, and somebody that you would feel comfortable would be parenting in a way similar to how you would parent. These are all in addition to the obvious, I guess, parenting qualities that you would envision.
Right. So talk a little more about the legal entity of a guardian versus maybe some of the other types of roles that support people could play in a situation like where a parent is deceased or incapacitated.
It's both the possibility of death, but also, like you said, incapacitation. So typically, I'll just let you know that typically in Minnesota, we would name a guardian in a will. That's the most common place to name that person. It's not the only place you need to do it, and I'll describe why. Sure. A will only has legal effect when someone passes away. When I prepare a will, if someone else got their hands on it, no worries to me, because what are they going to do with it? Right. It has no legal bearing until I pass away. So that speaks to the instance when a parent may pass away. If a parent is incapacitated, however, the will doesn't really give bearing. It's not a enforceable type nomination as much. So there's a supporting document beyond the will that we call a standby custodian nomination, and it speaks to the incapacity scenario, where let me talk a little bit about incapacity. Of course, it could be an illness or some traumatic thing where medically a parent is unable to provide care, or it could be something maybe less traumatic. Perhaps there are maybe international travels that have you stranded for a period of time, and there's a parenting decision that must be made, and you can't be reached for some reason. You can name in this document a standby custodian or a temporary guardian, and that speaks to incapacity. So when a parent considers, where to make this legally, of course you need to do it in your will. but also in the standby custodian nomination. They go hand in hand. And I'll take the opportunity to tell you something a little bit unique about that standby custodian nomination. It's actually recordable with the Department of Transportation, which sounds odd at first, but you can record this document. They maintain an electronic database, and they'll actually put a little indicator, a little icon on your driver's license. So, of course, the scenario is if there's, say, a car accident or something like that, the emergency worker sees this icon and it signals to them, check the database. They'll search, they'll see who you are, who your children are, who you've named as standby or temporary guardians, and it has all the contact information there, so that it can be a seamless
That's great to know.
transition. Yeah, it's a useful thing.
What about situations, and this, I know this doesn't necessarily fall in the situation of death or incapacitation, but what about, like oftentimes I've worked with kids where the parent will want to send them to a relative in another state to be cared for or whatever. Is that the same type of form that's signed? So if the grandmother, let's say in this situation, needs to make decisions regarding the child, is that same form?
Yeah, it would be. You can, again, the standby or temporary custodian nomination, you actually have the ability within the document itself to specify what types of scenarios you'd like it to apply to. And you can, if you have something in particular in mind, say a grandparent in another state, you can, specifically identify that as a possible scenario to which it should apply.
Right. So when parents make this decision, do they choose one, multiple people? Talk a little, a little bit about that process.
Sure. A little bit of the answer is going to depend on the parent and their philosophy in parenting. With a lot of decisions that one would make legally, it's best to choose an individual to avoid the potential for dispute among two folks that you've chosen. But selecting a guardian is a lot of times different from that. We're not just making financial decisions in a vacuum here. We're talking about kids. And if your philosophy is that it's best to be in a home where there's perhaps two caregivers, two parents, you may want to consider naming a couple. If that's less important to you, I suppose that's up to you, but it's a conversation to have perhaps with your spouse or with the other parent of your children, or with your attorney as you're making those decisions. But you can do either, and it's really a personal choice.
Right. So what if years go by? Let's say you do this, and 3 years later, Frank and Sue have divorced, and they may not be the couple you thought they were, at least at one point in time.
Sure.
Is that changeable? Is that easy to change? Maybe just talk a little bit about that.
Yeah, whether it's a will or a standby custodian nomination, they're definitely revocable. You can revoke them at any time. They're also just amendable or changeable, so that definitely is a possibility. Another thing to note as we're on that topic is when I'm doing planning for clients, an important consideration is making the document flexible. And so we'll think of a few backups. You'll pick your top choice.
Right.
And if it's a couple, you can say, I name the couple jointly or the survivor thereof or something like that. But you can also name contingent guardians in those documents as well. So yes, they're revocable if the circumstances change, or if the folks you named are no longer available or are simply unable to provide the care, they can decline their nomination and it can fall to the next folks in line. So as a parent is making that designation, don't think about just the best person or the best people, but think of a few contingent benefits.
And I suppose that would be important then to communicate to them too, that option would be there. I can think of actually one family that I worked with where the grandmother, again, her health failing became less of an option because she couldn't do some of the care, day-to-day care of the child. So she dropped down, so to speak, in terms of priority in being able to be a guardian.
It's a good point to note too that when a parent does make a nomination, it's truly a nomination. It's not an obligation, and there's a distinction to make there. So in that scenario, grandma, if she was in fact named, if the document hadn't been changed, she can say, I'm honored that you chose me, but I'm not in a good position to provide care, and can decline the nomination as well.
Okay. How much, when this actually, let's say a parent dies and it's brought to court, how much do children have a say in this process?
That's a good question. It depends on their age. Ultimately, the short answer is if a parent has made a nomination in a will, the court is going to give very great deference to that nomination of the guardian. A child can chime in though, and if it's a 16 or a 17-year-old child who's very close to adulthood, the court's going to weigh that fairly significantly. However, again, I think if we're going to say which one trumps the other, it's going to be the nomination of the parent that's going to carry the most weight.
Right, right. And then maybe talk a little bit about, so what's the follow-up? So let's say two parents tragically die in a car accident and they've nominated and guardian accepts and they go through the legal process. Is there any follow-up after that at least part of the legal process ends?
Yeah. I won't go into too much detail, but there's actually two different roles that we tend to lump together when we're talking about a guardian. And those roles are, number one, making decisions about the child, where they're going to go to school, what kind of medical care they'll receive or won't receive, and so forth. But there's also the financial element of it, and that person actually can be a different person. Oftentimes it's the same, but they have a different name, and that's the conservator. So there's the guardian and the conservator, and they manage two different things. So usually parents will name the same person, but you don't have to.
Can you think of maybe a scenario, where that may make sense?
Sure. I mean, if you have a family member who's particularly wonderful with kids, that would be a wonderful fill-in parent, if you will, but is notoriously lousy with funds. I mean, you may want, think of it how you want, a separation of powers perhaps, or just taking the skills and abilities of those folks that you know and applying them to the appropriate job at hand. The complication with naming more than one person is just a logistical one, though. If we need funds for this care, and on the other hand, the conservator isn't cooperative, it could create problems. But it's just one of many things to think through as you make those decisions.
Right. Yeah. Well, stay tuned with us. We'll hear more from Andy as we talk more about the roles of guardians with our children. We'll be right back. Hello and welcome back to Positive Parenting. We have our guest today, Andy Lehner, who is an expert on issues related to legal issues often associated with guardianship of children. And so we wanted to continue some of this discussion, Andy. We were wanted to talk more about some of these special situations. Situations like, for instance, if you have a child who may have special needs, who may be developmentally delayed, or other situations. Are there special things to be considering when choosing, for instance, a guardian in those situations?
Yeah. Well, similar to my answer before, it's your children the very best, and particularly when a child has special needs, as the parent, you know what those special needs entail, and you're poised and in the best position to choose the most appropriate guardian. So I don't know that the considerations, I can't describe how they're going to change, because of course it depends on the child. However, the way that you would name guardians for your child are going to start out the same as how you would name a guardian for anyone else. But there's going to be a continuation on that guardian nomination beyond the magic age of
Sure.
18 when the law says that you're an adult.
Right.
For, again, children who aren't under disability, they become autonomous at that
Right.
point under the law, but a special needs child does not. And so there's a new set of procedures that need to happen at that point. They're still called guardian and conservator proceedings, but they're no longer guardian and conservator proceedings for a minor. They're guardian proceedings for an adult.
Okay.
So the law says, someone can be incapacitated for a number of
Right.
reasons. One incapacity is minority, when you
Right.
haven't reached age 18.
Right.
Another incapacity could be on the other end of the spectrum, perhaps an elderly person who's suffering from dementia and has lost his or her ability to, understand and manage decisions about their own care. But then there's that, special scenario of someone with special needs, and they also are under an incapacity in the eyes of the law
Right.
and need to have a guardian in perpetuity. And in that instance, there's some special procedures to have a guardian put into place, even if a parent hasn't died at that point. So yeah, another important instance when guardianship plays a
Right.
key role.
Right. Now, common scenario, you have parents who are divorced, and at times not even amicably. So they may have differing opinions about who should really be the guardian of their child or children. Talk a little bit about maybe the process with that, how is that dealt with? Or perhaps if you have situations where you have an absent parent, maybe
Right.
that's not involved with the child, but parent dies, what rights might they have in this process?
It's a good question. As you know, I teach community education pretty regularly on this topic, and this topic comes up almost every single time because it is a common scenario. Yes, parents have parental rights by being biological parents of their children. A big, obvious understatement, I know. But those parental rights are very, very strong rights. And even in the face of a divorce, each individual and now separate parent still has parental rights to these children. And what that means is they both have equal, decision-making authority. So in that case, each one could make their own independent guardian nomination, but when they make it, they have to understand that if they don't agree on who the guardian should be, it's not as much of a slam dunk as it would be if they both agreed. So typically, when parents are acting together to name guardians, both parents would name the same person, and then it's a slam dunk. Right. But when there's a conflict like that, it's a little bit frustrating, but the decision ultimately will come down to the judge selecting the most appropriate, and the standard that the judge uses is the best interest of the child.
Right.
Whatever that means to that judge on that day.
Can you maybe talk a little bit about some of typical qualities or things that they might be looking for that you're aware of?
It's stability things, it's financial stability, it's the ability to provide a safe and stable home, it's all sorts of things, school districts. You did mention, Luke, the absentee parent as well. I just painted a picture where there are parents who are divorced, but both have an interest in their child's life. And there's, sadly, scenarios where one parent isn't interested. And in that case, the parent who is providing the care still can make a guardian nomination. But the parent who's absentee, even though they're absentee, they don't lose their parental rights. Right. A court can terminate the parental rights, but that's extremely rare. And again, it's a frustrating answer, but it's true, that disinterested parent could waltz back into the picture and exercise his or her parental rights and wreak havoc. There are instances where, say one parent is incarcerated or has an extensive violent, background or something like that, where the court almost certainly wouldn't name them. But just from the standpoint of a legal perspective, parental rights are strong rights, and they don't go away easily. And it's a rare instance when they're removed. Right. And only when they're removed would the other parent have the sole ability to name a guardian.
Right. Given some of the other questions that you often encounter in your teaching, are there other scenarios, other kind of unique circumstances that pop up enough that be worth commenting on?
Sure. Another instance that's a little bit related to take this blended family concept a little bit further is if there are step parents involved in the potential for adoption. it's conceivable that there's going to be, more than two parents,
Right.
and things get a little bit more dicey there. I guess the bottom line with any of these scenarios, whether the parents are married or not married but agreeable to one another, or perhaps they're not, if they can come to a consensus, that's going to be the best result for a child. And I realize that scenario sometimes just is not a reality.
Right.
But it can become, on one hand, more complicated with adoptive parents or step parents, but it can also, if there are two parents together in a home that demonstrates support, it kind of bolsters the case for that parent to be appointed by a court. I know these answers are not satisfying a lot of times to folks who are in that scenario, but it's kind of the lay of the land.
Well, and as always, seek competent legal advice, right?
Well, yes, of course, since you brought it up.
Right. But maybe that might be a good segue into just maybe talk a little bit about how this guardianship may fit into kind of larger issues or needs that parents should be thinking about in regards to their children.
Yeah. So naming a guardian or a conservator, again, the financial representative, is important for the reasons we've discussed. And they do fall into a larger framework that we would refer to maybe as an estate plan. Right. Sometimes people hear the term estate plan and they think of, aristocrats and wealthy folks. And, well, sure, they can benefit from a plan. But what I mean by estate plan is a collection of documents that address a variety of needs. One important one for parents, again, is the guardian nomination element, and that's done in a will, typically, and then also in that standby custodian nomination that I named. There's a couple of other really important, I'll call them estate planning documents, that come with a complete plan. One is a power of attorney document. It's a document where anybody who is legally competent can delegate authority to another person to transact financial business on his or her behalf. And the way that we use that in estate planning is as an incapacity planning tool. The power of attorney document has no authority once somebody has passed away, but if they're living but not able to understand or manage their own finances, you can name someone in this document to be a surrogate decision maker regarding your finances. The alternative to that, go ahead.
So can I ask what's the difference then between a conservator and a power of attorney?
Yeah. A power of attorney can only be done by someone who is competent in the eyes of the law. So it has to be someone who's an adult and not under any disability. And when they name someone in their power of attorney document, their attorney in fact is the name we use. Okay. They're delegating their own personal authority over their own personal finances to the person who's in that document. The guardian nomination or the conservator nomination is giving someone authority to manage a child's funds or the funds of somebody who's under some sort of other incapacity in the eyes of the law. Sure. Does that make sense?
Yeah, it does.
Okay. So another important document that is not directly related to guardian nominations but is an important consideration is the healthcare directive. Sometimes folks know this as a living will. And this pertains to medical decisions. Again, an incapacity planning tool, so that if someone is ever in a position where they're living but unable to understand or communicate their desires and wishes regarding medical care, this document comes into play in that instance. It does a few things. It names someone to be a healthcare agent to again, step in and make decisions where the principal cannot. But it also goes into a little bit more detail about particular types of medical care, that if you are in this scenario, what type of care would you want to receive, or which type of care would you particularly not want to receive. So again, the will is important for a variety of reasons, including guardian nomination. There's the power of attorney, the healthcare directive, and also the standby custodian nomination. And these things kind of work together to create what we would call an estate plan. Right. And from the perspective of parents of minor children, even these incapacity planning tool, documents that I'm talking about, like the power of attorney and healthcare directive, they don't comment directly on the children. But in fact, they, I'll say preemptively, answer questions that could blossom into disputes and create an environment of instability and increased trauma for a child. So they're maybe a little less directly towards the child a benefit, but they really are a benefit to the family as a whole.
Right. Well, talk a little bit. I know you go in depth about this much more in your community ed class. Could you maybe just speak a little bit about
Sure.
when you offer that?
Yeah. I tend to offer it approximately monthly, or at least every other month. I do it in a few different school districts in the area here, including District 197. And what we do is we talk about a lot of the things that we're talking about today. What is a guardian nomination? Why is it of consequence to me? Where can I name a guardian? And we actually go a little bit further than that. We take this standby custodian form that I've alluded to a few times. We actually take blank forms and we pass them around the room. And if two parents come together, which often they do, and they have thought through who would be the most appropriate guardian, we have the opportunity to complete that form together as part of that class. I bring my little notary stamp, and we'll go ahead and even put into place an official guardian nomination as part of that class. And as you know, as always, I mean, the community education venue, it's a very inexpensive fee, and you can grab a lot of information and even walk away with a good, solid legal document.
Right. And appreciate knowing that as a resource in the community that people can turn to.
Yeah.
So Andy, thank you so much for sharing tonight your thoughts on what makes a good guardian and what the process is all about. We hope you've enjoyed tonight's show. If you have comments or questions about tonight's show or have suggestions for future shows, please do not hesitate to contact us at positiveparenting@townsquare.tv. Until next time.